Whenever I'm about to engage in a conversation about the Electoral College, I always think back to my childhood cartoon G.I. Joe. This is Cobra Commander here giving his plan of attack. And I always think about this because it's a reality I have to tell myself. Most people that want to talk to me about the Electoral College don't know why we have it. A large amount of people don't even know the makeup of our country by state or how we were founded. So it's not a surprise to me whenever an electoral college incident happens, whether it be a court ruling on it or a movement to abolish it. It's important to address it, but also remember, most people don't know what they're talking about. And that includes myself. So I always recommend to all of my viewers, go out, do your own research. I put all the links to the stuff I'm going to talk about in the comment section so that you can do your own research. And it's important to do that, especially on a topic like this, because lack of research leads to lack of understanding. Lack of understanding leads to bad interpretation. And some bad interpretations are what I have seen about this recent Supreme Court unanimous ruling. So let's read it over and we'll talk about it. The Supreme Court ruled unanimously Monday that a state may require presidential electors to support the winner of its popular vote and may punish or replace those who don't, settling a disputed issue in advance of this fall's election. Justice Elaine Kagan wrote for the court as it considered for the first time the issue of faithless electors, and whether the Constitution sees members of the Electoral College, whose votes ultimately elect the president, as representatives of the intent of their state's voters, or as independent thinkers. The Washington state law at issue reflects a tradition more than 2 centuries old, Kagan wrote. In that practice, electors are not free agents. They are to vote for the candidate whom the state's voters have chosen. In an opinion that referred to both the Broadway musical Hamilton and the HBO sitcom Veep, Kagan added, "The state instructs its electors that they have no ground for reversing the vote of millions of its citizens. That direction accords with the Constitution as well as with the trust of a nation that here we, the people, rule." Lower courts had split on the issue, with one saying the Constitution envisions the electors as free to vote their conscience without fear of punishment or removal. It was one of the rare political cases at the court that seemed not to favor one political party over another, which might explain the unanimous verdict. Justice Clarence Thomas disagreed with the majority's reasoning, but not the outcome. Red and blue stakes alike urged the justices to settle the matter in advance of the white-hot glare of November's election. They said they feared that a handful of independent-minded members of the Electoral College would decide the next president. Also not before the court was an initiative by some states to pledge their electors to the winner of the national popular vote. The court considered cases from the states of Washington and Colorado. Washington moved to fine Peter Brent Schifalo and 2 others $1,000 after they voted for former Secretary of State Colin Powell when the Electoral College convened after the 2016 election. They had pledged their vote for Hillary Clinton, who won the state's popular vote. Colorado replaced Michael Baca after he said he intended to vote for Ohio's then-Governor John Kasich instead of Clinton, who won his state. Baca was part of a movement to try and deny Donald Trump the presidency. As the court's opinion noted of the 2016 contest, only 7 electors across the nation cast faithless votes, the most in a century, but well short of the goal. Candidate Trump became President Trump. The Washington Supreme Court ruled for the state, saying the Constitution's directive that gives the states the power to select members of the Electoral College also means they can set the standards those electors must follow, such as living up to their pledge to support the state's popular vote winner. A panel of the U.S. Court of Appeals for the 10th Circuit went the other way. It said Colorado's control ended with deciding how electors from the state are chosen. From there, it said the Constitution envisions that the 538 electors are free to vote their minds in deciding who should be the president and vice president. All but 2 states have winner-take-all systems, and 32 plus the district require those running to be electors to pledge to support the state's winner. Most simply expect the electors to honor the statewide result. The electors are chosen by the winning party after all. Only 15 have penalties for punishing or replacing electors who break their word or have a change of heart. Still, some states worried that faithless electors could determine the outcome. The 2000 election, for instance, was one decided by 5 electoral votes. Kagan acknowledged that history shows that a number of votes cast by rogue electors were counted by Congress, but none came close to affecting the outcome of the election. Since the founding, electors have cast some 180 faithless votes for either president or vice president, she wrote, and that is 180 out of over 23,000. And more than a third of those faithless votes come from 1872, when the Democratic Party's nominee died just after Election Day. Putting those aside, faithless votes represent just 0.5% of the total. Kagan said both history and the bare-bones instructions in the Constitution weigh in favor of state restrictions. The challenging electors said that the Constitution's words about electors voting in a ballot for president require them to have freedom of choice. Kagan noted their argument that Alexander Hamilton in the Federalist Papers praised the Constitution for entrusting the presidency to men most capable of analyzing the qualities needed for the office, who would make their choices under circumstances favorable to deliberation. But, she wrote, even assuming other framers shared that outlook, it would not be enough. Whether by choice or accident, the framers did not reduce their thoughts about electors' discretion to the printed page. Harvard law professor Lawrence Lessig had represented those asserting the independence of electors. When we launched these cases, we did it because regardless of the outcome, it was critical to resolve this question before it created a constitutional crisis, he said in a statement. Obviously, we don't believe the court has interpreted the Constitution correctly, but we are happy that we have achieved our primary objective. This uncertainty has been removed. That is progress. And we go back to this paragraph here because it's very important to understand the Supreme Court sided with the Washington Supreme Court. And at first it seems like it's a victory because after all, last time it was people trying to leave the Trump camp. They were not following the will of their state's people. So whether we like it or not, they've given the states carte blanche into telling them how they must elect and who they must elect. And this is important because I'm telling you that this is not necessarily a good thing, and I'm going to show you why here in a second. But first, let's look at some of the people who were actually bringing these suits up to the Supreme Court, because that's important, because history can tell us a lot. Let's read about this guy. The 24-year-old presidential elector in Colorado had a different plan. Weeks earlier, after Donald Trump's victory in the general election, Baca and a fellow elector began a movement they called Hamilton Electors, a long-shot bid to stop Trump from winning the presidency. The idea was to persuade enough members of the Electoral College, the body of 538 members who vote for president, to instead cast ballots for Republicans, such as former Ohio Governor John Kasich, depriving Trump of just enough electoral votes required to become president. And here's where they give away why they're doing this entire thing. Quote, certainly the entire point is to get the Supreme Court to address this issue, which has never been addressed on its face before, Wesowski said. The ruling comes as a growing number of states are rethinking their electoral college systems in response to the 2016 election. And here's the key. After Trump won the presidency, despite losing the popular vote by almost 3 million votes. So let's take a look at this victory that Donald Trump supposedly just squeaked by, because we just heard earlier in the article that Bush won literally by 5 electoral votes. This looks like an electoral landslide. 306 to 232, it wasn't even close. Trump received 304 electoral votes to Clinton's 227 electoral votes. Clinton won the national popular vote with 48.2% of the vote, while Trump received 46.1% of the vote. Clinton and Trump criticized each other over character issues and shared divergent views on America's role in the world. Now, I'd like to just point out here, she won a plurality of the popular vote, but she would have to have 50.1% to have actually won the actual popular vote, which neither candidate did. So let's keep that in line. Neither candidate won the popular vote. So they're roughly separated by 2 points. And then it goes on to say, the negative tone of the 2016 presidential election led to the highest third-party vote total since 1996. Former New Mexico Governor Gary Johnson left the Republican Party for the Libertarian Party nomination. Johnson received 3.2% of the vote, while Green Party candidate Jill Stein received 1.07% of the vote. In Michigan, Wisconsin, and Pennsylvania, the Johnson and Stein vote totals exceeded the margins of victory for Trump. The people who write these things are so obtuse. Your bias is showing. Listen, Trump lost by 2% popular vote, and they just said Gary Johnson left the Republican Party and got 3.2% of the vote. Hello? They don't make the comparison to popular vote and say, oh, if there wasn't a third-party candidate in Gary Johnson, that would put Trump 3 points higher and that would put him above Hillary Clinton in the popular vote. No, they point to the fact that if every person that voted for Gary Johnson and Jill Stein voted for Hillary Clinton, then she would have won these specific states. It is deliberate misleading. So far, 16 states, including Colorado, have passed laws that would award all their electoral votes to the winner of the national popular vote, a nationwide initiative that would virtually wipe out the need for an electoral college if enough states join. Baca told the Post he supports the national popular vote movement, but for the time being, he said, electors should be freed from laws that force them to vote for a candidate. I want to see everyone in this country have a fair vote, he said. I don't think I should have been allowed to do what I did, but it was allowed under the Constitution. Okay, guys, so let's talk about what that guy just said. He just said he didn't think that he should be allowed to do what he did, but he found that our Constitution allowed him to do it, and so he did. That's the literal definition of subversion. Okay? They're going to come into our system and use our system against us to get what they want. This is right in front of your face. These are the guys, these anti-Trumpers, who really, let's be honest, were the first ones to attempt a coup on the president by trying to take the Electoral College away from him, something that he had won handedly. These are the guys who are at the Supreme Court right now, and they're arguing in favor of electors to be able to choose who they want to elect freely. The states are defending their right to determine who the electors vote for. The Supreme Court has solidified that the states have the right to tell the electors who to vote for. So they announced this Supreme Court decision, and I'm looking around me and I'm seeing all these conservatives celebrate this. It's a unanimous decision. What have I always told you guys? Anytime, anywhere in American politics you see unanimous agreement, it should perk your ears up and you should be paying close attention to it. Now, the article earlier mentioned briefly that not before the court was a movement of states that were forcing their electors not to vote for who won the popular vote of their state, but force them to vote for who won the popular vote of the country. Now, the article says this issue is not before the court, but I argue that the court just decided this issue. They said that states have the right to determine the rules around who electors should vote for. This means that if the state legislature signs up for this popular vote group, the electors of that state must vote the way that this legislation is determined. So let's give you an example. Let's say in Colorado, Donald Trump wins the popular vote of Colorado State. However, Joe Biden wins the national popular vote by 500,000 votes. The electors of Colorado will be forced to vote for Joe Biden, even though Donald Trump won the popular vote of the state of Colorado. And I know a lot of people aren't taking this popular vote movement seriously yet, but I need to draw attention to this because I can't see a way around the legitimacy of this movement. So let's go through their webpage and you tell me what you think. The nationalpopularvote.com. Agreement among the states to elect the president by national popular vote. The National Popular Vote Interstate Compact will guarantee the presidency to the candidate who receives the most popular votes across all 50 states and the District of Columbia. The compact ensures that every vote in every state will matter in every presidential election. The compact is a state-based approach that preserves the Electoral College, state control of elections, and the power of the states to control how the president is elected. The National Popular Vote Bill has been enacted by 16 jurisdictions possessing 198 electoral votes, including 4 small states, Delaware, Hawaii, Rhode Island, and Vermont, 8 medium-sized states, Colorado, Connecticut, Maryland, Massachusetts, New Jersey, New Mexico, Oregon, and Washington, 3 big states, California, Illinois, and New York, and the District of Columbia. The bill will take effect when enacted by states with 74 more electoral votes. And that would be Arkansas, Arizona, Maine, Michigan, Minnesota, North Carolina, Nevada, Oklahoma, Virginia. A total of 3,408 state legislators from all 50 states have endorsed it. The shortcomings of the current system of electing the president stem from the winner-take-all laws that have been enacted by state legislatures in 48 states. These laws award all of the state's electoral votes to the candidate receiving the most popular votes in each state. Because of these state winner-take-all statutes, presidential candidates have no reason to pay attention to the issues of concern to voters in states where the statewide outcome is a foregone conclusion. In 2012, as shown on the map, all of the 253 general election campaign events were in just 12 states, and 2/3 were in just 4 states, Ohio, Florida, Virginia, and Iowa. 38 states were completely ignored. And here's their little map. They're really into these huge maps whenever they're trying to confuse people about the Electoral College. So here's where all the campaign events happened, and it's so unfair. And here's a map of the U.S. with state sizes based on the number of campaign events in 2012. And similarly, in 2016, they can make a map about that too. And this is how big and creepy the states would look if they based the map off of how many events that happen there. It's crazy. And here's a map of what the country would look like if we gave bears the right to vote. But seriously, number of campaign events is a stupid metric to make maps over, because if you want to have more campaign events in your state, then you need to be a more of a swing vote state, have, equal amounts of conservative and Democrats. If your state is always Republican or always Democrat, then they're not going to come campaign there. Why would they? But anyway. Also, because of state winner-take-all statutes, 5 of our 45 presidents have come into office without having won the most popular votes nationwide. The 2000 and 2016 elections are the most recent examples of elections in which a second-place candidate won the White House. Near misses are also common under the current state-by-state winner-take-all method of awarding electoral votes. A shift of 59,393 votes in Ohio in 2004 would have elected John Kerry despite President Bush's nationwide lead of over 3 million votes. All right, listen up. The National Popular Vote Interstate Compact will go into effect when enacted by states possessing a majority of the electoral votes. That is, enough to elect a president, 270 out of 538. At that time, every voter in the country will acquire a direct vote for a group of at least 270 presidential electors supporting their choice for president. All of this group of 270 plus presidential electors will be supporters of the candidate who received the most popular votes in all 50 states and D.C., thus making that candidate president. And since I love their maps so much, I figured I would put one out here. This is the presidential election without the Electoral College. Let's take a brief second to understand why we have the EC. We are not a single country like France or Germany. We are a United States. So think of the USA as Europe, where each of the countries in Europe are a state. In America, we've all decided to be states under the same country. That decision is a very delicate one. For instance, when they were debating representation, smaller states that provided important things to the Union wanted to have representation equal to the people who had high population states. Now, normally the high population states would just say, no, go kick rocks. But we needed those states. We needed to be a United States. And so even the small states needed a say-so. If we reverse the Electoral College, and the outcome of the elections are basically determined by California and New York, what you're going to see is a balkanization of the United States of America. And if you don't know what that means, go look it up. Because small states that are conservative have no reason to remain in a union that they do not have representation in. And if their state is going to get chip whipped every presidential election, they will leave. Mark my words. This ruling by the Supreme Court has really reinforced this interstate agreement, because now if the legislatures of the states agree that their electors will vote for the country's popular vote, now this Supreme Court decision says that the states have the right to tell the electors how to vote. One step at a time. The slow creep of subversion. And I just want to jump in here to let people know this is in no way a blanket defense of the Electoral College. I think a couple of the states that do ratioed numbers have a good idea. But what these people are suggesting is we take what is a problem and turn it into a different problem, but one that benefits them. We're going to have to keep an eye on this. Anyways, guys, like, share, sub. I'll talk to you later.